Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. A government cannot choose not to stand by a parliamentary enactment, a 7-judge bench of the Supreme Court has said, debating a point of order with the government's law officer in a case concerning the minority status of the Aligarh Muslim University, AMU. Questioning the centre for its disagreement with the parliamentary amendments in 1981 that sought to grant minority status to the Aligarh Muslim University, AMU, the Constitution Bench pointed out that the government and its law officers should support the amendments until Parliament exercise its supreme power to make subsequent changes. It highlighted that till then, such decisions have to be defended before a court of law by the government, irrespective of the dispensation in power. The Supreme Court has directed a Madhya Pradesh-based company which manufactures and sells whiskey under the trademark London Pride to inform if it was willing to change the trade address and colour of its product as they were similar to liquor major Pernod Ricard India Private Limited's Blended Pride and Imperial Blue Whisky. A bench headed by CJI Diva Chandrachud asked senior advocate S. Muralidhar, appearing for brand London Pride, to seek instructions and inform it about the company's response by the next date of hearing. The legal battle over the alleged infringement of the trademark of the whisky brands witnessed an unusual sight in the Supreme Court on January 5th as liquor bottles were placed before the country's highest court. The top court was hearing a petition by the liquor major Pernod Ricard India Private Limited, which manufactures and sells Blended Pride and Imperial Blue Whisky, against last November's verdict of the Madhya Pradesh High Court. The courts cannot direct the government to notify a law passed by Parliament, the Supreme Court has observed while dismissing a PIL seeking implementation of certain provisions of the Insolvency and Bankruptcy Code. It is up to the government to notify a law passed by the Parliament, and it is beyond the power of the court to issue writ of mandamus to government directing them to notify a certain law. An accused cannot seek default bail on the grounds that the probe is pending against other accused or the charge sheet filed by the probe agency is incomplete, the Supreme Court has said, while cancelling the bail granted to former DHFL promoters Kapil Wadhawan and his brother Dheeraj in the multi-crore bank loan scam case. The top court said that the benefit of the proviso appended to subsection 2 of the section 167 of the CrPC would be available to the offender only when a charge sheet is not filed and the investigation is kept pending against him. However, once a charge sheet is filed, the said right ceases, it said. Now let's have an overview of high courts. The Jharkhand High Court has observed that women in India are obligated to serve their elderly mothers-in-law or grandmothers-in-law. The court also quoted some lines from the Manusmriti and termed serving the elderly in-laws a cultural practice. Dealing with a petition challenging an order passed by a family court wherein a man was asked to pay maintenance of Rs 30,000 per month to his wife and Rs 15,000 per month to his minor son, the court also underscored that the wife's insistence to live separately from her in-laws is unreasonable. It is the culture in India to serve the aged mother-in-law or grandmother-in-law, as the case may be, by the wife. In order to preserve the culture, the court said. Reciting lines from the Manusmriti, the court said, where the women of the family are miserable, the family is soon destroyed, but it always thrives where the women are contented. Calling it a serious concern, the Bombay High Court has asked the Maharashtra State Police Chief to personally ensure that lower-ranking officials properly maintain case diaries and are aware of the seriousness of the issue. While hearing a petition filed by a man seeking a direction for his wife, an Uzbekistan national, to produce their month-old daughter, Justice Ajay Gadkari and Justice Shyam Chandak noted that the procedures mandated by the Code of Criminal Procedure (CrPC) were not followed by the Mumbai police. During the case hearing, the court called for investigation papers and noted that the case diaries were not being maintained by a police as mandated by the law. The bench observed that the case diary was maintained in utter defiance of Section 172(1)(b) of the CrPC, which states that the diary containing the day-to-day entry of the proceedings in the probe has to be duly paginated. The Jharkhand High Court, while quashing proceedings against the director of a company accused under the Negotiable Instrument Act, reiterated that when the accused is the managing director or a joint managing director of a company, it is not necessary to make an avertment in the complaint that he is in charge of and is responsible to the company for the conduct of the business of the company. a director or an officer of the company who signed the check renders himself liable in case of dishonor. Other officers of a company can be made liable only under subsection 2 of section 141 of the NI Act by averring in the complaint their position and duties in the company and their role in regard to the issue and dishonor of the check, disclosing consent, connivance, or negligence, the court said. The Delhi High Court has opined that incidents when seen in isolation may not be relevant, however, when viewed together clearly depicted a non-adjusting attitude of the respondent due to which the appellant suffered mental cruelty. It was observed that the discord between the parties was not a mere normal wear and tear of marriage, but when viewed comprehensively, were necessarily the acts of cruelty towards the appellant, making their continuation in matrimonial relationship an act of perpetuation of cruelty. The Punjab and Haryana High Court, while quashing the summoning order against the accused in a murder case, observed that merely for the reason that the petitioners have been named by the complainant, the power under section 319 CrPC cannot be exercised unless and until the evidence on the record satisfies a test of more than prima facie case. The court further referred to the decision of the court in the case of Municipal Corporation of Delhi versus Ram Kishan Rohatgi and others, wherein it was held that if the prosecution can at any stage produce evidence which satisfies the court that those who have not been arraigned as an accused or against whom proceedings have been quashed have also committed the offence, the court can take cognizance against them under section 319 CrPC and try them along with the other accused. The Patna High Court has held that amendment under Order 6, Rule 17 CPC can be allowed at any stage as may necessary for determining the real questions in controversy between the parties. The court observed that if the amendment is denied, two sets of contradicting pleadings will be entered into the record, adding needless complication and impairing the fair and appropriate disposition of the issue in front of the learned lower court. A Pakistani court has restored the bail of former Prime Minister Imran Khan in 7 cases against him in connection with the May 9th violence on military installations. However, the order of the Lahore High Court may not bring any relief to the 71-year-old founder of Pakistan Tehreek-e-Insaf ahead of the February 8th general polls in the country. Pakistan Supreme Court has stripped the PTI of its iconic cricket bat election symbol, a move after which those contesting in elections from the party will have to fight as independent candidates. The Election Commission of Pakistan has already rejected the nomination papers of Imran Khan and several of his party colleagues. China's top court has committed to deepen judicial discourse in response to unusual public criticism from lawyers and legal experts regarding its plan to restrict access to court decision. The Supreme People's Court (SPC) announced in December its intention to establish a new database comprising over 2,000 cases which would be accessible to scholars, lawyers, and experts. It is anticipated that this new database will eventually replace the existing open database China Judgments Online, which currently holds 143 million court documents and remain available online. China Judgments Online, a decade-old archive, has been utilized by lawyers, activists, citizens involved in property and business disputes, as well as human rights organizations in China and internationally. Meta's Facebook and Instagram have been held responsible for subjecting minors to sexual harassment, which includes the distribution of explicit images of adult genitalia, according to an internal company estimate from 2021. Based on an internal estimate, social media platforms reportedly exposed almost 1 lakh children to exploitation through inappropriate content and images. These sensitive findings were disclosed in a recently unsealed sections of a complaint filed by the Attorney General of New Mexico in ongoing legal battle against the social media giants' safeguarding efforts related to minors on the internet. In the end, we have miscellaneous news. The Supreme Court has launched on a pilot basis a project to help share scanned, digitized paper books with advocates on record. The project was launched after an issue about variation in page numbers of scanned and digitized paper books during court proceedings was flagged. Such variation often causes grave inconvenience and loss of invaluable time for the court and the members of the bar, the court notice reads. The Punjab and Haryana High Court has issued notices to the Bar Council of Punjab, Haryana and Chandigarh and the Bar Council of India in a petition seeking directions for standardized stipend and remuneration guidelines for providing young lawyers and law interns with a minimum stipend. The petitioners have sought that young lawyers be given 15,000 and law interns be given rupees 5,000 standardized stipend. It has also been pleaded in the petition that the respondent bar counsels not restrict young advocates from filing independent matters, as the same is in violation of their fundamental rights to earn livelihood enshrined under Article 21. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.